So, now let us go into the third writ, the writ of prohibition. Prohibition is a judicial writ issued by a superior court to an inferior court. So, unlike mandamus and the habeas corpus, this is a judicial writ. And why this judicial writ is issued? It is issued by the superior court to the inferior court, restraining from continuing the proceedings. That means, the higher court will issue this writ to the lower court, and the purpose of issuing that writ is to stop the court from further proceeding with the case. So, to stop the proceedings which are ongoing in the lower court. So, this is one of the oldest writ largely used in restraining the inferior courts from encroaching into the jurisdiction of the superior courts. So, unlike other writs which are corrective in nature, that means if the habeas corpus, if your detention is illegal, it is corrected by the Supreme Court. Under mandamus, if a person is not doing his duty, it corrects it. But this writ of prohibition is preventive in nature. That means, the writ of prohibition comes into picture when the proceedings are still pending before the lower court, and it prevents the lower court from taking a wrong decision. So, therefore, it is preventive in nature compared to other writs. So, the base or the prime aim of prohibition is to prevent the authority from continuing a proceedings any further. It will ask them to stop the proceedings there and then. On what grounds you could ask for prohibition? The first ground is lack or excess of jurisdiction. That means, a lower court or any quasi judicial body exercising the jurisdiction where it does not have a jurisdiction, or it has a jurisdiction but exceeds the jurisdiction. In both the cases, you could ask for writ of prohibition. For example, if an authority has a power to grant licenses, but it starts a proceeding to cancel the license, that is exceeding the jurisdiction, you do not have it, you can't do it. And but the prohibition cannot claim to correct the proceedings followed by the authority. Therefore, whether the issuing of the writ of prohibition is not to correct the proceedings, but it is to see whether the authority has a jurisdiction or not. For example, whether wrongfully they admitted the evidence, whether they are considering an evidence which they are not supposed to consider, for those things you cannot ask for writ of prohibition. Writ of prohibition would be asked only if they do not have a jurisdiction. While taking the case, any errors was made by the court cannot be questioned under the writ of prohibition, because these mistakes could be asked to be corrected under preferring an appeal. The other grounds on which you can ask for prohibition is violation of fundamental rights, violation of principles of natural justice, or infringement of a law. That means, when the lower court proceedings violates fundamental rights, violates principles of natural justice, you could also ask for writ of prohibition. For example, if the petitioner was not allowed to present his evidence, that is, right to fair hearing is affected, or the authority having some interest, for example, a bias, and the first principles of natural justice is violated. So, you could ask for writ of prohibition. When this writ of prohibition cannot be asked, when the proceedings are already completed. Please remember, we already discussed that the prohibition is not a remedial writ, it is a preventive writ. Therefore, if the proceedings are already completed, then there is no point in asking for prohibition. You can't prohibit because the proceedings are already completed. And second one is, you can't ask writ of prohibition for preventing executive actions. If an executive is doing something which he is not supposed to do, you can't ask for prohibition, you have to go for mandamus. And the third situation where you can't ask is against any administrative, executive, or ministerial functions. Again, this would come under the purview of mandamus, but not under the purview of prohibition. So, therefore, prohibition is not a remedial writ, it is more into a preventive writ. Therefore, you prevent the miscarriage of justice, you ask for prohibition. But what happens if the proceedings are already completed and the miscarriage of justice already happened? You can't ask prohibition, but you could ask writ of certiorari. So, therefore, the prohibition and writ of certiorari are similar in nature. The grounds, everything is similar in nature. But prohibition comes when the proceedings are continuing, certiorari comes when the prohibition, certiorari comes when the proceedings are already completed. So, let us look into how this writ of certiorari works. Certiorari means to inform. So, initially this writ was developed by the king. Whenever the king requires to certify the information, he is to issue the writ of certiorari. So, whenever he wants an information to be provided to him, he will issue the writ of certiorari. So, therefore, it is an order by the court to any judicial or quasi-judicial body to transmit the record of the proceedings disposed or pending therein to the scrutiny of the higher court. Therefore, the king can ask the lower courts or lower authorities to send certain records to them for verification. So, now in a modern day, the writ of certiorari was transformed from higher court to the superior court to the lower court, that the lower court should send the records to the superior court to see whether the proceedings were properly conducted. So, the idea of writ of certiorari is to correct the gross errors made by the lower courts. So, the purpose of the writ of certiorari is like in prohibition, to keep the inferior courts within the limits, but prohibition works more when the proceedings are still alive. Certiorari comes when the proceedings are completed. So, by issuing this writ, the superior court can even quash the orders of the lower court. Therefore, in that sense, this writ is a corrective in nature. So, prohibition is a preventive in nature, certiorari is a correct in nature. The grounds for granting certiorari, of course, most of the grounds are same as prohibition. First one is lack of jurisdiction, that is without having jurisdiction. What are the examples of without having jurisdiction is authority wrongly assumes jurisdiction or authority wrongfully constituted, lack of jurisdiction both territorial or subject matter, law conferring the jurisdiction to the authority is unconstitutional, or failure to observe the procedural requirement, like for example serving the notice, applying the grounds, allowing the person to represent himself, etc. The second one is excess of jurisdiction, that means authority has jurisdiction but exceeds the limits. Third ground is abuse of jurisdiction, when authority uses its jurisdiction for improper use or in bad faith or for extraneous considerations, the authority uses its jurisdiction. Fourth one is violation of principles of natural justice, and fifth one is error apparent on the face of record. Now, the fifth one, that is error apparent on the face of record, means error itself is evident. That means you need not produce any further evidence to the court to come to a conclusion whether the order issued by the lower authority is in error of law. That means the error is so apparent, it is so patent, it is so manifestly shown in the record, by mere reading the record is sufficient to see that there is a error. So, when this writ cannot be asked, number one, you can't ask the writ to correct the errors of facts, it is only errors of law. And second one, you cannot ask the writ against any person having no judicial or quasi-judicial authority in deciding the disputes. So, it applies only to judicial and quasi-judicial. And you can't ask writ of certiorari in the third ground is that to declare any law is ultra vires to the constitution, that cannot be asked under a writ of certiorari. So, therefore, both writ of prohibition and certiorari seems to be similar, but the prime difference is that one is a correctional one, other one is a preventive one.